Hi there, this is Jonathan Ginsberg. I'm an Atlanta area personal bankruptcy attorney. And today I'd like to talk to you about what you can do in bankruptcy about leases. And typically when I'm talking about leases, I mean a vehicle lease, a car or truck lease, could be furniture, rent-to-own type of furniture lease, could really be any type of lease at all. And basically for bankruptcy purposes, a lease is considered an executory contract. And what that means is that the contract has not yet been fulfilled. You're making ongoing payments on the lease, and at the end of the lease, you will either have to turn the vehicle or furniture, whatever the case may be, back in, or in some cases, you can enter into a contract to purchase it. So a lease does not give you any ownership rights. And a lease, because of that, by the way, is treated as an unsecured debt in a bankruptcy. Even though there's property behind it, it's considered unsecured because you have no interest in the property and the property is not tied to the lease contract. Well, in a bankruptcy, you have the option of either rejecting the lease or assuming the lease. And if you reject the lease, basically that means you can walk away from the lease contract at no penalty. So for example, if you have a leased vehicle and it's costing you $700 a month for that leased BMW and you realize you can't afford it and you're in a bankruptcy, you can basically, by rejecting the lease, walk away from that vehicle and have no future liability. The remaining lease balance payments would not be due, as opposed to if you simply turn the vehicle back into the leasing company, you could get sued for the remaining value of the contract. So bankruptcy is a very powerful tool when it comes to rejecting leases, and the same goes for rent-to-own contracts. Typically, I see them in furniture or appliances, where you lease an appliance or furniture for a period of time. And again, if you go into a bankruptcy, you may decide that that doesn't make a lot of sense. And by the way, rent-to-own type of contracts usually don't make a lot of sense. But in any case, you can use the rejection of the executory contract in your bankruptcy to walk away from it. And typically, by the way, when you do that, if you reject the contract, you're going to have 3 or 4 weeks before you have to turn it in. One of the nice things about bankruptcy is that when you're in bankruptcy, even if you reject the lease, the creditor can't simply come pick up your vehicle. They've got to give you some notice and they've got to make arrangements to come get it. So it does give you a little more planning opportunity when you reject a lease in a contract. But big picture is, if you have a lease you can't afford anymore, bankruptcy is an option that you can use to reject that lease and walk away from it and not have any liability going forward. So I hope you found this helpful. If you did, please give it a thumbs up on YouTube, like on Facebook, subscribe to our channels both on YouTube and on Facebook. If you have any questions for me about anything related to personal bankruptcy, Chapter 7 or Chapter 13, please let me know.